chapter, we're covering personal property and bailments. And really, we're focusing on what happens, what legal rights do we have when our personal property is not in our possession any longer. So personal property is defined as everything that can be owned other than real estate. There can be tangible and intangible personal property. So real estate is obviously land and buildings attached to it. That's called real property. Personal property is everything else. And it can be tangible or intangible, and we'll define what those mean on the next few slides. So tangible is property that has substance. It can be touched. So anything I can touch, feel, pick up, all of that is tangible personal property. It's also called goods or chattel, and it's movable. Like I said, I can pick it up and move it. It includes animals and crops. Intangible, on the other hand, is property that's not perceptible to the senses and cannot be touched. So these are things that maybe a patent, right? So if I have a legal patent, it's written on a piece of paper, but the asset that I'm actually protecting is something I can't touch, right? It's the right to a process. A stock certificate is the right of ownership. These are intangibles. They're also called chose in action, which means evidence of the right to property, but not the property itself. I can own personal property outright, or I can own it in different ways. I can own it in severalty. That's when I own it outright, but I could also own it in co-tenancy, and that's when it's owned by more than one person. So if it is owned in co-tenancy, it is called either tenants in common or joint tenants. And really, the operation of these two concepts is the same until one of the owners dies. So in tenants in common, each co-tenant's share of the property passes to his or her heirs upon death. If I own a car with my neighbor and I die, and if we own it as tenants in common, my share of the car passes to whoever my heir is. But if we owned it as joint tenants, then each co-tenant's share of the property passes to the surviving joint tenant upon death rather than their heirs. So in my car example, if I pass away, now the entire car is owned by my neighbor. We also may own property as in community property, and that is when property, except by a gift or inheritance, that's acquired by the personal efforts of either spouse during the marriage, would belong to both spouses equally. And whether or not this applies to you depends on which state you live in. So there are 9 states that recognize community property, and they are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. So again, this is in a marriage. Anything that I go out and acquire, work for, whatever, any assets I bring into the marriage but that I earned during the marriage are treated as owned equally by both spouses. So as it says on the slide, that excludes anything I get by gift or inheritance. That could be mine solely, and that's going to exclude anything I bring into the marriage. If I own a house before I get married and I bring it into the marriage, then I can still own that individually, but everything else would be owned in community. All right, so now we're going to move into what happens if I don't have possession of my personal property anymore. Depends on why. So if it is lost, if I lose my property, the finder of lost property has a legal responsibility to make an effort to learn the identity of the owner and return that property to the person who owns it. In contrast, if it's abandoned, then it has treated as been discarded by the owner without the intent to reclaim it. I do not generally have to try to find the owner and give it back. And really the difference in lost and abandoned property is going to kind of depend on the circumstances of the find. So if I am at the grocery store and there's a wallet sitting at the checkout counter and it's not mine, that's clearly lost property. The previous customer just set it there and forgot to pick it up. If, however, I am in the middle of a park where where there aren't many people and I find a wallet just thrown on the ground, that may or may not be abandoned property. So I really have to look at the circumstances of the find. The law of finds gives ownership to the finder of abandoned property if all of the following apply. The property is abandoned, the finder intends to acquire the property, and the finder has possession of the property. The law of salvage is going to apply when the find happens because of a sinking ship, a shipwreck. So the law of salvage gives the salver, who is the one who salvages, the right to compensation for assisting a foundering vessel. Salvage is the reward given to persons who voluntarily assist a sinking ship or recover its cargo from peril or loss. If an abandoned shipwreck is found in the submerged land of any state of the U.S., the Abandoned Shipwreck Act of 1987 applies rather than the law of fines or the law of salvage. That act gives states the right of ownership to shipwrecks found beneath their waters. So an individual cannot take possession of things found on a shipwreck. The act is going to give states the right to possession of any of that property. You can also receive personal property by gift, and to have a completed gift, which means to have legal right to keep property you receive by gift, all three of these must have happened. So the donor, who's the one giving the gift, must intend to make a gift. The gift must be delivered to the donee, who's the one receiving it, and the donee must accept it. So there must be intention to give, delivery, and acceptance. Once all three of those are met, the gift cannot be taken back by the donor. It's known as an absolute gift, or a gift inter vivos, between the living. So at this point, I usually have students ask or consider a broken engagement. So generally a broken engagement, the gift of an engagement ring would be a completed gift and could not be taken back. So the donor would have intended to give the ring. It was delivered, and if the donee accepted the proposal, that's usually a completed gift, and the donor cannot legally repossess the ring. The Uniform Transfers to Minors Act regulates gifts made to minors, and it says that it assures that minors who receive gifts will either be used for their benefit or made available to them when they become adults. So we've been talking about inter vivos gifts among the living. There are also gifts in Causa Mortis, and these are gifts that are given during one's lifetime but in contemplation of imminent death from a known cause. So a person is in the hospital, they've had a heart attack, the chances of recovery are slim, and they make a gift. So the requirements here, the requirements for making a gift Causa Mortis, are the same as those requirements for making an inter vivos gift. So there has to be intention to give, delivery of the gift, and acceptance of the gift. But there are two pretty important differences. So gifts given Causa Mortis are revocable. So the actual right to keep the gift is only secured once the donor dies. Remember, inter vivos gifts, once all three of those conditions were met, the gift was irrevocable. Here, it kind of adds a fourth. The donor has to actually die for the gift to be irrevocable. And the second difference is that if the situation that caused the donor to be in contemplation of impending death passes, the gift is automatically revoked. All right, now moving on to stolen personal property. So if you have possession of property that is stolen, it's going to change the legal rights to that property. So usually presumption of title to goods follows possession of them. But it's possible for a person to have possession of goods without having title, just as it's possible for a person to have title without having possession. In stolen goods, the true owner never relinquished title to the goods, so even an innocent purchaser who acquired the goods in good faith and for value would be obliged to return the goods to the owner. And this is an important point to consider, to pause and consider. If you buy something at a pawn shop, for example, and that was a stolen good, okay, and you acquired it in good faith and for value, you could still be required to return the goods to the owner. Because title to the stolen goods never left the owner, and possession can always be regained by that owner if the goods can be found, no matter in whose possession they may be at the time. All right, so that's stolen property. Now we're going to move on to bailments. And bailments involve situations where other people have possession of my property, but they have possession because I allowed them to have possession. So it's distinguished from stolen goods because I didn't allow them to have possession. So in a bailment, it's the transfer of possession and control of personal property to another with the intent that the same property will be returned later. The bailor is the person who transfers the property, and the bailee is the person to whom property is transferred. A type of bailum called a mutum is when an individual loans goods to another with the intention that the goods may be used and later replaced with an equal amount of different but similar goods. An example of that would be a monetary loan contract. If I were to make a loan, I expect money back, but I don't necessarily expect my dollars back, right? It's a fungible good that all I care about is that I have enough dollars. Okay, so now we're going to talk about different types of bailments. So first, bailments for the sole benefit of the bailor are called gratuitous bailments. That's when property is transferred to another person without either party's giving or asking for payment of any kind. Those bailments lack consideration. Bailments for the sole benefit of the bailor is when possession of personal property is transferred to another for the purposes of benefiting only the bailor, and bailments for the sole benefit of the bailee only benefit the bailee. In these gratuitous bailments, property is transferred to another person without either party giving or asking for payment, and since they lack consideration, they may be rescinded at any time by either party. Parties to such agreements usually consider them only as favors. So, in reality, though, definite legal responsibilities are placed upon both the bailor and bailee. So if I am going out of town and I take my pet, for example, to my neighbor, and they agree to watch my pet, and no consideration has changed hands, that is a bailment for the sole benefit of me, the sole benefit of the bailor. And either party can rescind it at any time. My neighbor can call and say, I'm not doing this anymore, or I can come home early and I can take my pet back, right? There are also mutual benefit bailments, and that's when personal property is transferred to a bailee with the intent that both parties benefit. These things are, for example, that when you valet your car, or when you have a consignment contract. And a consignment contract is when you deliver a good to someone in the business of selling those goods, and that person is going to take a cut of whatever sales price they get for your good, and you get the rest. So a consignment contract is a type of mutual benefit bailment in which the consignor entrusts goods to the consignee for the purpose of selling them. So the rights and responsibilities are a little different here. In a mutual benefit bailment, the bailee owes a duty of reasonable care for the good. And reasonable care means the degree of care that a reasonably prudent person would use under the same circumstances and conditions. And then the bailee, the one who has the good, is responsible for ordinary negligence, which is the failure to use the care that a reasonable person would use under the same circumstances. So when bailments go bad, we have to consider the burden of proof. And the burden of proof has two meanings. It describes the responsibility of the party who must present evidence to prove or disprove a relevant and material fact in a court case. And it also refers to the amount of proof that's required for a favorable decision to be rendered in the case. So in a bailment, most courts shift the burden of proof to the one who is in the best position to know what happened, which is generally the bailee, the one who has the good. When items in the possession of a bailee are damaged, lost, or stolen, the burden is on the bailee to prove that it was not because of negligence. Okay, so moving on to different types of bailments. Now we're going to talk about innkeepers, carriers, and warehousers. An innkeeper is the operator of a hotel, motel, or inn that holds itself out to the public as being ready to entertain travelers, strangers, and transient guests. Transient guests are those whose length of stay is variable. To assist travelers in obtaining accommodation, so places to stay, common law imposed the duty upon innkeepers to accept all people who requested a room if one was available. In addition, innkeepers were considered insurers of their guest property. With some exceptions, these standards are still the law today. Innkeepers are not liable as insurers in 4 cases: losses caused by a guest's own negligence, losses to the guest's property due to acts of God or acts of the public enemy, losses of property due to accidental fire in which no negligence may be attributed to the hotel keeper, losses arising out of characteristics of the property that cause its own deterioration. So if you stay at a hotel, oftentimes they might have a safe in the room, and they do that to prevent their liability for theft, because if you do not place your valuables in a safe, that would be your own negligence. So that losses caused by a guest's own negligence would be a situation where an innkeeper was not liable for loss. Carriers are businesses that undertake to transport people, goods, or both. So this is another type of bailment. A common carrier is a carrier that holds itself out to the general public to provide transportation for compensation. The Carmack Amendment to the Interstate Commerce Act states that a carrier is liable for damages to goods transported by it unless there is proof that the damage occurs because one of the following exceptions: acts of God, acts of the public enemy, acts of public authorities, acts of the shipper, or the inherent nature of the goods, meaning they're carrying things that are perishable, evaporating and fermenting liquids, or maybe diseased animals. All right, and now warehousers are people engaged in the business of storing goods. This is another type of bailment. So that's the warehouser, is the one who stores the goods. The warehouse is the building or structure in which any goods, but particularly wares or merchandise, are stored. A warehouse receipt is a receipt issued by a person engaged in the business of storing goods for hire. Although both common carriers and warehousers are mutual benefit bailees, they perform different functions. Common carriers are engaged in moving goods. Warehousers keep goods in storage. At times, though, one or the other will perform both functions. Warehousers may be classified as public or private. And a public warehouser is one that owns a warehouse in which any member of the public who's willing to pay the regular charge may store goods. A private warehouser, in contrast, is one whose warehouse is not for general public use. And a warehouser's lien is the right to retain possession of the goods until the satisfaction of the charges imposed on them. So sometimes business people will borrow money using goods they have stored in a warehouse as security for the loan. The one who lends the money is given the warehouse receipt. If the debt is not paid, the holder of the receipt may obtain possession of the goods in storage. That's called field warehousing. A warehouser must use the amount of care that a reasonably careful person would use under similar circumstances. Failure to use that care is negligence and makes the warehouser liable for losses or damage to the goods. All right, now finally, moving people, common carriers of passengers. A passenger is a person who enters the premises of a carrier with the intention of buying a ticket for a trip. One continues to be a passenger as long as one continues the trip. And as you know, this is heavily regulated. The FAA, Federal Aviation Administration, has established regulations that require the screening of passengers and property before they enter an aircraft to search for dangerous weapons, explosives, and other destructive substances. Passengers who don't consent to this type of screening must be refused transportation. So if you have flown any in the last 10 years, you know that screening is arduous, long, but necessary. Prior to September 11th, common carriers had an obligation to accept all passengers who sought passage over their lines, but this rule has changed. If they suspect for any reason this person should not fly, then they are allowed to deny service. Racial profiling is something that has been a hot topic since these new regulations have come about. People have argued that they have been profiled. Racial profiling is the act of targeting a person for criminal investigation primarily because of racial or ethnic characteristics. This is not allowed to be a motivating factor in a carrier's decision to refuse transportation. A passenger who's boarded a plane that is not taken off must leave the plane if told to do so by an authorized airline representative. The carrier must exercise reasonable care in the protection of passengers. Injuries that are reasonably foreseeable or preventable and that result from the carrier's negligence give the passenger a right to sue for damages. But if injuries are not reasonably foreseeable or preventable, the carrier is not responsible. So carriers are really grappling with their responsibilities to keep people safe, and they are removing people from planes, for example, and people are filing lawsuits saying that they have been racially profiled.